LUC must be done in accordance with the HRS Section 205-4, and a request that the LUC clarify and affirm that the parcel is not encumbered by the requirement to provide off-site infrastructure to the 150-acre agricultural park. This was an inadvertent error. The remainder of the document is consistent with the pleadings, and the body of the staff report reflects that. The amended staff report correcting the error was posted on 1/7 in the morning. The AG has advised us that the correction of the error and subsequent reposting satisfied disclosure requirements.
Thank you, Mr. Orendenker. Ms. Kwan, I heard that the recording was started midway through that.
Yes, Mr. Chair.
So I'd like to go back and get Commissioner Kamakelo on record in the recording. So Koike, could you restate your location and affirm you were there alone, just for the record?
Yes, Chair. This is Commissioner Kamakelo, and I am joining this hearing via Zoom from 560 North Nimitz Highway here in Honolulu. My office is here in Iwilei, and I am in fact in my office alone, attending the meeting. Mahalo.
Thank you so much. Mahalo. Okay, at this time, I'd like the parties to introduce themselves. Petitioner.
Yes, thank you, Chair. Commissioners, Terry Lee, counsel for the petitioner, RK2 Partners. Also attending is my colleague Ernie Martin and Mike Matsuura. And also in attendance are principals of RK2 Partners, Mike Wright, who is here in person, as well as Garrett Beck, who's participating by Zoom, and Bo St. Gem, who is participating by Zoom.
Mr. Lee, do any of your associates plan to give testimony as part of your presentation today?
No, I will be the only speaker.
Okay, but if we do need to call on them, we'll swear them in at the time. So, Mr. Lee, I'd like to review the reimbursement policy and get your acknowledgement. Have you reviewed HAR 1515-45.1 regarding the reimbursement of hearing expenses?
Yes,
And you accept them?
yes.
Thank you very much. At this time, we'd like to deal with any potential disclosures or conflicts of interest. So in accordance with HRS 84-14, commissioners are not allowed to take any official action affecting a business in which they or a member of their family has a financial interest. They must therefore recuse themselves from this matter if there's any benefit, monetary or otherwise, to themselves or members of their family. Also, in accordance with legal ethical standards, commissioners should disclose any relationship, business, social, or otherwise, that they may have with the petitioner or its representatives, or any other parties to this proceeding that may give rise to an allegation of bias or impropriety. So commissioners, do any of you have any conflicts of interest or disclosures to make at this time? Seeing none, we'll proceed. As a reminder, this declaratory ruling petition, so the procedure will be slightly different from our standard contested case approach. Here's the process we will follow for this agenda item. We will begin by acknowledging any written testimony that has been submitted regarding this matter. Next, I will open the floor to members of the public who wish to provide oral testimony on the matter. Once the public testimony is complete, I will call upon representatives from the petitioner, and they will be called upon to make their presentation. After the petitioner's presentation, the commissioners will have an opportunity to ask questions to provide comments. I will also invite, although it's not mandatory as a next step, to the county and city and county of Honolulu if they wish to provide testimony on this matter. And I will also invite the Office of Planning and Sustainable Development if they wish to provide public testimony on this matter. Then I will reopen the floor to other new and additional oral testimony on this matter. And finally, the commission will deliberate on the matter on the testimony and presentations presented. The commission will then determine what action, if any, it will be taken in response to the petition. Okay, please be informed that the relevant records and documents pertaining to this matter can be accessed for review on the LUC website. I'm going to say this twice, https://luc.hawaii.gov/dr24-78. Once again, that's https://luc.hawaii.gov/dr24-78. I will now recognize the written public testimony submitted in this matter. Ms. Kwan, could you tell me about the written testimony that has been received?
Yes, Mr. Chair, we've received 5 written testimonies on this matter. All have been posted to the website. Staff was unable to check this morning if any additional testimony came in due to Wi-Fi connection issues.
Thank you. But all 5 have been posted. Are there any members of the public that wish to testify on this at this time? Public testimony. Anybody signed up?
If there's anyone on the Zoom who would like to provide oral testimony, please use the Q&A feature now.
And let me reiterate to the City and County of Honolulu and to the Office of Planning and Sustainable Development, I will invite you to provide testimony after we hear from the petitioner, if you are so inclined to do so. I do acknowledge that you have both submitted written testimony and it's appreciated. Back to you, Ms. Kwan. Anybody?
Still seeing none, Chair.
Anybody in the room sign up?
Seeing none, Chair.
Thank you. So, time for a presentation, Mr. Lee. I will turn it over to you and you have the floor.
Thank you, Chair. For the record, I'd also like to point out that a representative of the petitioner, Ed St. Gem, has also logged into Zoom.
St. John?
St. Geme. I'm not quite sure how to pronounce it. Gem, I think. But
Okay.
I want to explain to the commission why we're filing this petition. And I think the reasoning for filing the petition and seeking these orders will help the commissioners make a policy decision as to whether to grant the petition. And the simple reason for it is, as everyone knows, this land is slated for development. My clients intend to develop very needed industrial facilities to fill the scarce supply of warehouse industrial properties on Oʻahu. There's also a later phase where they commercial center to serve the community in that area. And as we know, Haseko is planning to develop quite a few housing units, of which by law, it has to provide a certain percentage of affordable housing. So I think it is fair to say that this commission, as well as all of the regulatory bodies involved, OPSD, Department of Ag, DPP, would like to see the development proceed. Well, for developments of this magnitude, the developer must be able to finance the project. In order to finance the project, the underwriter, the lender, who underwrites the financing for this project, evaluates what the risks to the development are. One of the chief risks of this development is the fact that currently it appears to be the LUC's position that if any of the conditions that were imposed on the original order changing the land use classification from ag to urban are not satisfied, then it can simply file an order to show cause and change the classification because of the failure of a condition. That is a serious risk to a developer, and it's a serious risk that a lender will look at in assessing whether to finance any development of this project. And so my request to have the commission determine that if any reclassification would occur, it has to be done pursuant to the statute and the holding in the DW Ainalea case, substantially lowers that risk. The other important thing that is unique to our property is the fact that in 2003, I believe, the owner of our property, HRT, negotiated a deal with OPSD that it would acquire the 150 acres for the ag park at its cost and give it to the Department of Ag. And there's no question in the record, and none of the testimony that was filed contests that fact. And I also know that the amount that HRT paid back then, which is over 20 years ago, was $5 million. So it paid a substantial amount of money to acquire this 150 acres, to convey it to the state for the benefit of the state. And in exchange, it provided, the stipulation clearly provided, and I provided you a copy of the stipulation, that a condition of this conveyance is the LUC shall enter an order, essentially holding that the 150, the industrial property, HRT's land, would not be encumbered by the requirements of condition 19 to provide offsite infrastructure improvements to the ag park. And when you think about it, that seems like a fair exchange because HRT paid for the land to convey it to the state. So why should it also have to be concerned about contributing to the cost of the infrastructure improvements to service that land? Well, fast forward 20 years later, and frankly, not surprisingly, OPSD, Department of Ag, even DPP, all regulatory agencies, mind you, are opposing this request. Why? Well, because they view this, their position from a very narrow lens. And that lens is that of a regulator. So they naturally want to keep as many restrictions on the developer as it can in order to, whatever regulatory objective or I guess perhaps their perception is if we hold this gun to their head, it'll compel them to perform. I don't think there's any question that they want performance. They want the developments to proceed, but they view it from a regulatory lens and not from the developer's perspective. And that's why I feel it's so important for the commissioners to understand that, look, you need to have a broader look at this thing. If you really want to see the developments proceed, then you have to lower the development risk so that a lender will be willing to provide financing. None of these developers intend to finance this out of their own pocket. They have to get financing from a lender. And institutional lenders, which would which would be the only source of financing for projects of this magnitude, dig very deep into these issues. I've built my entire career, over 40 years, representing developers, and I know this. So that is why we are seeking the relief provided in the petition. Now, does the LUC, do you have the authority to grant such relief? Clearly, yes. None of the opposing testimony by OPSD nor the staff report indicates otherwise. So why should you grant it? Well, pure and simple, because it's the right thing to do. HRT bargained for a certain benefit. It performed it. And here we are over 20 years later, and it still hasn't realized the benefit it bargained for. So that's why I'm here. I'm asking this commission to give us that benefit. The other reason is because as a policy matter, as I just explained, you will help enable development to go forward because you reduce risk. You're not eliminating all risk. No development is risk-free. But by reducing the risk, you make the land and the projects more financeable. Now, this is something I feel compelled to make the commission and the rest of the state agencies involved aware of. And it's certainly something I do not want to ever have to deal with. But if the commission does not rule that my client's industrial land is not encumbered by the Condition 19 obligation to provide offsite infrastructure improvements to the ag park, then the condition upon which HRT agreed to convey the land to the state would have failed. And any lawyer who's taken first-year real property law and contracts cannot dispute the fact that that failed condition would entitle the party to rescind the conveyance. How is that of benefit to the state? It's not. And so that's another compelling reason why I think the commission should grant the petition. Now, the staff is recommending that this matter be converted into a contested case proceeding. And as best I can understand its rationale, it feels like there needs to be a factual record further developed and more legal authority provided to support our position. With all due respect to the staff, I disagree. On the issue of whether there has been substantial commencement of use of the land, the petition area, I think the record is full of facts that confirm that. Ho'ohana's expenditure of $200 million to develop the solar farm, in and of itself, I would submit, constitutes substantial commencement of use. But then you factor in all the money that Haseko has spent in the planning and development of infrastructure for their project. You know, we're talking easily 10 million plus. This is just in soft costs, not hard construction costs, soft costs, payments to engineers, consultants, and the like. And my client, who has spent considerable amount of money obtaining tentative subdivision approval before the DPP for their industrial development, as well as all of the engineering that goes into planning for the on-site infrastructure improvements that are required. So I think it's fair to say that if you were to tally up all the money that the parties have spent, it's easily, in the magnitude of $225+ million. That's substantial commencement of use. So, having said all that, I would encourage the commission to not turn this into a contested case proceeding and to grant the relief that we've requested in the petition. Thank you.
Thank you, Mr. Lee. Commissioners, any questions on the petition to the petitioner? One more time. Any questions for the commissioner? Petitioner? So I got a note from the Deputy Attorney General. She asked me to read this for the record. If we lose internet connectivity today, we will continue any unfinished business from today during the continued meeting, which is tomorrow, January 9th, 2025, starting at 9 a.m. As noted on the agenda, reconvening at the time, which is 9 a.m. tomorrow. So if we lose the internet and we lose our Zoom connection, sorry, but we'll try to fix it on the spot. But if we are unable to do that, we'll see you tomorrow morning. Okay. We're good for now. Commissioner Lee.
Thank you, Chair. For the petitioner, what is your response to several claims that the work that was commenced did not apply to your specific parcel?
So that is the testimony that was filed by Jennifer Lim on behalf of Ohana. And I apologize. It was not clear to me that the work that it did for the ag park was not pursuant to the condition 19 requirements, but rather a separate set of conditions that related to the commission's approval of the subleasing of that land, the leasing of that land to Ohana by Robinson Estate for purposes of developing the solar farm. So in that regard, as the commission knows, this record is quite voluminous. And it feels like, to me, who's the new kid on the block, like drinking from a fire hose. And so I simply, overlooked that fact and misunderstood what that was for.
Good. Okay, commissioners, anything further? Thank you very much. So at this time, I'd like to invite public testimony from the City and County of Honolulu Department of Planning and Permitting, if they so choose. You have no public testimony at this time? I presume you stand on your written testimony, but please state for the record, if you would.
Aloha Maika'a Co-Chair Commissioners Pono Arias, Deputy Corporation Counsel on behalf of the City and County of Honolulu Department of Planning and Permitting. The city rests on its written testimony, but is available for questions if any commissioners have.
Would you like those questions now if we have them?
Yes, that's fine.
Commissioners, do you have any questions on the written testimony that's been provided by the City and County of Honolulu? I see none, so thank you very much.
Thank you.
Also, at this time, I'd like to invite Office of Planning and Sustainable Development, who have provided written testimony, as to whether you'd like to provide any oral testimony at this time. Ms. Kato, please state your name and for the record.
Sorry. Good morning. Alison Kato, Deputy Attorney General for the Office of Planning and Sustainable Development. We did submit written testimony, so all our reasons are in there. So we're also going to just send our written testimony, but I do want to comment that, OPSD is not commenting on what the order should say. We're just commenting on what it does say. We're stating what it currently says. To the extent argued otherwise, we don't believe that this declaratory order is the correct vehicle. I'm available for questions.
Thank you, Ms. Cato. Any questions for Ms. Cato from representing OPSD? From commissioners?
I got a question.
Mike.
Chair.
Commissioner Kahele, turn on your mic, state your name and
I got a question. So OPSD's recommendation is to deny the petition in the January 6th, I believe, letter that was sent to Dan Arndecker.
That's correct.
So what does the petitioner needs to do to fix it?
Well, I mean, this
Been working
declaratory,
on this project for years.
yes, I mean, this docket is 33 years old, I believe, 34, since it was reclassified. I mean, we did mention a few different reasons, just procedurally, you know, we consider this to be speculative because there is no order to show cause. No one's made a motion to seek to revert this property. No one's asking for an order to show cause. It's petitioner that has raised this issue. So we just don't think that this is a situation where substantial commitment is in question. Unless there is an indication that an order to show cause is likely to occur in the near future, which we don't see. But, you know, even considering the substantive question, OPSD views, you know, the petition area, yes, at one time was all one owner, one project, but currently it is now different projects, different owners. So I guess pointing to the other landowners' work on their projects on different parcels of land, we don't believe is sufficient to say that there's substantial commencement of petitioner's property. And so we believe there's a lack of evidence put forward for that finding.
So I'm sorry. So we're talking specifically on R2K's petition, right?
Yes.
On their property at 100, I believe 123 acres.
Mhm.
So that's not including the solar farm and
No,
all the other
that's,
stuff.
those are
So
different.
specifically their
Mhm.
project. All right.
So I mean, yes, they've indicated in their petition that there has been considerable cost and tentative subdivision approval and no further. OPSD feels that there should be evidence of use of land, not just conceptual plans. And regarding petitioner's second issue regarding the offsite infrastructure, again, we're looking at the past documents and what actually occurred. Yes, OPSD did make an agreement with petitioner that we would support an arrangement where they were released from certain conditions if they transferred the ag park. So OPSD did put forward a motion to request that. The OUC at the time, the commission at the time disagreed. And so they changed that arrangement. And the petitioner at that time agreed at the hearing. So we're really just saying what we see in the documents as what the order currently says. As far as changing the conditions, we believe that would be a motion to amend if their intent is to change that condition. Or they should have clearly stated that at the time if that was the intent. But the documents don't show that.
All right. Thank you.
Commissioner Lee.
Thank you, Chair. I guess I'm kind of, seems like there's some gray area because while on the one hand, Ms. Cato, you stated that no one's questioning reversion or anything or pushing for it, so it's speculative. But on the other hand, you mentioned that you still don't feel that or OPSD still doesn't feel that any work has commenced. So it's like, because no one has asked the question yet, but if the question were asked, they would not have been commenced, right? Which is what they're trying to say. So just wondering if you could elaborate a little bit on that.
By us saying that no one is seeking an order to show cause, we mean that no one has made a motion to seek an order to show cause. There is no order to show cause currently in existence. We don't intend to file one, or we don't know what the intent of the commission is. But so far, no one has raised that question.
So, Commissioner Lee, so if someone were urged to make that question, then it would be ripe, and then now you would say, well, in our opinion, no work has commenced.
We would need to see what evidence. If that question were raised, then the petitioner would need to provide sufficient evidence, and we would need to look at it at that time to evaluate whether there has or has not been.
Okay, thank you.
Thank you. Commissioners, anything further? Thank you, Ms. Gatto. Once again, we will give members of the public an opportunity for a second round of public testimony based on what they've heard to date on this matter at this hearing. So, Ms. Kwan, are there any members of the public who now wish to provide new testimony on this matter?
Yes, Mr. Chair, we have Jennifer Lim on Zoom who would like to add to her testimony.
Thank you.
I'm going to promote her now. Miss Lim, can you hear me?
I can. Can you hear me?
Yes, we can.
Thank you very much. I'll make this brief. Thank you, commissioners, and thanks for having this hybrid meeting. It's extremely useful for those of us who weren't able to get into town today. I submitted on behalf of my client, which is Ho'ohana Solar 1 LLC, I submitted testimony yesterday. I hope that the commissioners have had a chance to look at that testimony, and most particularly at the photograph evidence that was attached to that testimony. And I feel compelled to speak because I want to make sure that the question and answer that I just heard from, I believe it was Commissioner Lee, and Petitioner's counsel, Terry Lee, that there's not some confusion. Ho'ohana Solar 1, just to be clear, we are a lessee. We are not a landowner. We are a lessee of about 30% of this entire petition area. My client, Ho'ohana Solar, has built a massive solar farm, and it is not substantial commencement. It is done. That project is built out, and that's why I'm hoping, and perhaps Ariana could confirm this, if the commissioners are able to access the photographs that I submitted with that testimony. And the reason being that when we last appeared before the commission in, I think it was March of 2024, this commission had already at that time determined that there had been substantial commencement on the use of the land, all right? Remember, we're a portion of the petition area, but it's all the petition area. In that time, so the photographs I submitted yesterday had some of the photos that we had showed the commission in April. The photographs that I submitted yesterday as Exhibit B show the status of the project now, and it's absolutely gorgeous. I mean, all the pieces are in, all the panels are in, all the batteries in, you know, things are being commissioned like as we speak. So I wanted to make sure that the commission and Mr. Lee understood that although we're not taking a position on his petition for declaratory order, we believe very strongly that we've provided ample evidence to show the commission that there has been more than substantial commencement. But in terms of the solar farm, which is about 30% of the entire petition area, the project is essentially complete. And I see that Ariana has pulled up those photographs. Thanks very much. So that's all I wanted to say. And I'm here for questions, but I won't take up any more commissioner time unless you have anything further for me.
Thank you, Ms. Lim, and thanks for joining us today. So commissioners, any questions on Ms. Lim's comments or her photographs? Commissioner Lee.
Thank you, Chair. And maybe this question should be towards LUC staff, but I'm still not clear on whether completion as well as commencement of this solar farm counts for the property that RK2 is talking about.
Mr. Orndecker.
Thank you, Mr. Lee. That's a very good question. And to be honest with you, staff is uncertain, which is why in the staff report, we suggested an evidentiary hearing so that all the parties could present their evidence with regard to various issues and brief some of those issues. We just don't know the answer is because it's never been presented to us in this manner before.
So, Mr. Orndecker, just to clarify for the record, originally the petition area was several hundred acres. It has since been divided among different owners, of which RK2 is one. And Ms. Lim is leasing from a different owner of a different section of that original 500. And they have built a solar farm on that parcel, to which the current instant petitioner has no rights to it. It is separate. So it's the first time you've ever seen this situation?
That is correct. I mean, Chapter 205 provides that we can issue an order to show cause and revert all or part of the property or part of the petition area, which in this case is divided up into several different parcels. So we are actually we would be looking forward to hearing the various parties brief that and to provide us with argument as well as evidence as to whether or not, assuming, I mean, there's a question as to whether or not the construction of the solar farm is in fact substantial commencement, given that it's a temporary use. But that issue aside, assuming for the minute that it is substantial commencement, does that apply just to that parcel or does it apply to all the parcels? We just don't know the answer.
Okay. Commissioner Miyasato.
Thank you, Chair. I guess with that said, in regards to the second portion of the declaratory ruling, would that also be true for offsite obligation, infrastructure obligation, that it was a condition for the entire property? All owners, 5 owners?
That is correct. And once again, that is why we're suggesting an evidentiary hearing, because we're not sure how those requirements have been broken up and who is responsible for what. So.
Okay, thank you.
Chair, I got a question,
Commissioner Kahele.
and I'm kind of confused here. So if we deny the petition that's currently being requested, the other projects are going to be impacted? Mr. Orndecker?
Who are you asking?
Mr. Orndecker.
Mr. Orndecker.
Again, that's an evidentiary question that we don't know the answer to.
So is this the only project that's currently holding up the entire project? Sorry, Denker.
Holding.
Yeah.
Holding up?
Yeah, because apparently we don't grant this petition. Everyone else is kind of like held in limbo, eh?
I don't believe that that's the case. The project continues to move forward under the existing decision and order. This is an attempt by the petitioner, RK2 Partners, to remove the enforcement provisions from their portion of the property. And it's understandable. I mean, I heard the argument and it's understandable. However, we're not sure that the evidence supports that. We've gotten testimony from Department of Agriculture and OPSD that there is some question here. And that's why we're suggesting the evidentiary hearing.
All right, thank you, Dan.
Question,
Who's that?
Bruce.
Commissioner Wu.
A question for the petitioner. If kind of what Commissioner Kahele said, what will be the outcome if we deny the petition, and what will be the different scenarios, the potential scenarios that we might face, or you guys might face, or I guess the community might face, or your partners would face? Could you give us some scenarios?
Sure. Thank you for that question.
Mr. Lee.
Oh, I'm sorry.
So Commissioner Wu asked that specifically if we denied it, but I'd like to expand that to your response. So if we deny it, what will be the expected consequence? And if we decide to approve it, what will be the consequence? And if we decide to request a contested case, what would be the consequence? Give us all three scenarios.
I just wanted to add one more. As I read through the process of from start to beginning, you need a roadmap to follow this process of what's happening among the commissioners prior to us, and hopefully it ends here. So what I'm hoping not to prolong this process that's been prolonged for years, and hopefully we can find some type of solution. It's my goal to not pass it. I've noticed it's my first year on the commission. We have a lot of redundancy from prior years, so hoping we can nip it. But thank you, and I thank you, Chair, for the clarification of what is it? Yes, the true sinners. Mahalo.
So let me start by responding to something that OPSD testified to and the questions raised by Commissioner Kahele and Lee. I think the simplest way to look at it is OPSD would like to have their cake and eat it too. And what I mean by that is, on the one hand, their position is the conditions originally imposed by the Land Use Commission to reclassify the land from agriculture to urban encumbers all of the properties, irrespective of who owns it. Okay. I accept that. But then, when we seek to present to the commission that, look, the $200+ million and the completion of the solar farm that Oʻahu has done doesn't apply to us. Well, why not? It's 30% of the petition area, as Ms. Lim indicated. Isn't that substantial commencement of use? It's more than that. It's substantial use of the petition area. So you can't, on the one hand, say, oh, all those conditions encumber everybody's land. But when it comes to determining whether there's been substantial commencement of use, oh, no. Now we're going to separate ownership, and each individual owner has to demonstrate substantial commencement of use. That's not the law. If the commission is going to go in that direction, then
One second.
Yes.
That was public testimony by OPSD. That was not the commission speaking.
Oh, no, yes, no, absolutely. And that's what I'm sorry if I was not clear. That is what I am arguing against. As a matter of law, there's no factual evidence you need for that determination. This is a matter of law. Okay? So, what happens if you deny our petition? The reason why I am trying on behalf of my client to reduce the risk factors that a lender would look at in determining whether to finance our client's project is because we are already addressing a substantial risk factor vis-a-vis Haseko. Haseko, we have an agreement with Haseko. We call it the Second Amended and Restated Infrastructure Agreement, where Haseko has committed, just between us parties, okay? It's nothing necessarily involving any other party, where they're going to do certain roadway improvements. And we need those roadway improvements to have access to our property. And so we're dealing with Haseko in good faith and to try to get them to move along with that aspect of their work in order for us to move forward with our work. Okay? Well, that's something a lender is going to look at very hard. To the extent that I can indicate that, hey, in addition, that is a risk, and we're working with Haseko to ameliorate that risk. But to the extent I can also indicate that we don't have to worry about the Land Use Commission filing an order to show cause to revert some or all of the petition area back to ag, is going to be a very significant consideration for the underwriting lender, right? And so by being able to improve the financeability of my client's land, that helps facilitate its ability to move forward with the development. If you deny that, you're going to frustrate my client's ability to finance the project, as well as finance Haseko's ability to finance the project. Ohana is done. They don't need any more financing. They spent all the money, they're done. But, you know, you still got the other developers that need to minimize the underwriting risk that a lender would look at. I'm sorry, Chair.
The second scenario is we approve the petition.
If you approve the petition, it enhances the financeability of the land, my client's project, as well as Haseko's, as well as Robin Estate to the extent they have any other land that they might be looking to develop. By enhancing the financeability of the land, you're encouraging and facilitating the development of the land, which is what the commission is hoping to achieve.
And the third scenario is if we request a contested case for evidentiary hearings on your.
You're just basically kicking the can down the road, because I get it. LUC staff is a bit challenged in trying to figure out, okay, now that the ownership has been split up, who's responsible to do what? And how does it impact the satisfaction of the conditions and so on? I've been in this situation in another development project on Kauai involving Grove Farm. And my client was Safeway. Same thing, the Land Use Commission imposed all these conditions, but then the ownership split up. And so who is responsible for what? The way the parties resolved it is the way HRT and Haseko resolved it, is they get together and they privately negotiate who's responsible for what. Because it's not the Land Use Commission's responsibility to make that allocation. And if you try to bifurcate these obligations, you're going to be in these hearings for years. And I don't think it's necessary. I think you should allow the parties to make those determinations, which in certain circumstances, you know, my client and Haseko have done.
So I think you confused me a little bit with that last comment. So let me ask you to back up with the following. So what would be the consequence that you see if we proceed with a request for a contested case on the issue of substantial commencement? And separately, what would be the consequence if we ask for a contested case on the issue of the condition 19?
Okay. So on the first one, the issue of substantial commencement of use. the question of who's responsible for what is an inevitable issue. Do you bifurcate those obligations among the different
No,
property
no,
owners
not,
or
no,
not?
we're just saying a yes or no, it's substantial commencement has occurred.
Yes, but
Not a bifurcation. The bifurcation is on, if I understand it correctly, that you're worried about is can we say condition to 19 applies to this party and not that party or all parties or something? So,
no.
am I misreading you?
So OPSD's position is that substantial commencement of use must be demonstrated by each individual property owner.
Yeah, that's their public
Right.
testimony.
So if that's going to be an issue, and I think if I heard Mr. Ordendaker correctly, that's something that the staff is struggling with. They don't know what the answer to that is.
I think what I heard from Mr. Orndenker is we'd like a little more evidence on the record one way or the other before we can, so we could inform the commission so it could make the best decision possible on that question.
Well, and I guess my retort to that would be, Ho'ohana has provided evidence that it spent $200 million. It's shown you pictures. That's 30% of the petition area. What additional evidence do you need to demonstrate not just substantial commencement of use, but substantial use of the petition area? But I mean, if that's not enough, then I don't know what is. Now, so that's why I think, I mean, and maybe I'm being presumptuous here. If the commissioners feel that 30% use of the petition area is not sufficient to satisfy the standard of substantial commencement of use, okay, well, then I guess you need more, you need more. But I would submit as a matter of law that you have the facts. That's enough as a matter of law. If you think that substantial commencement of use has to be demonstrated by RK2 for its 123 acres, well, that's a whole separate issue, right? That's a bifurcation issue. And that's going to be a morass for the commission because then you're going to have to decide, okay, well, what is RK2 responsible for? Which conditions? And how much, you know, how, because you're bifurcating the obligation now. You're saying that in order for us to show substantial commencement of use, it has to be unique to our property, not the entire petition area. Well, if you say that, well, that means then the conditions that are encumbering all of our respective properties, all the different landowners, it should be bifurcated. And I don't think that's a road you want to go down because it will be years to resolve that one.
Okay, the last point was if we have a request a contested case on the second item that you're requesting, which is relief from condition 19, what would be what do you view to be the consequence of us making that request?
See, a contested case proceeding is really a proceeding in order to receive evidence and resolve factual issues that are relevant. I would submit there are no factual issues that need to be adjudicated. The fact is, and no one has contested this fact, is HRT and OPSD reached an agreement that if HRT acquired the 150 acres and conveyed it to the Department of Ag, that its 123 acres would not be encumbered by the obligations of condition 19 to build the offsite infrastructure improvements for the ag park. That's the only relevant fact. I am not sitting here arguing that this commission is bound by that. What I'm arguing is that this commission should grant that relief because that was what was bargained for over 20 years ago. and HRT perform its part.
So in your understanding of that agreement and your client would be relieved from that condition?
Just that condition.
Yeah,
that's right.
who, just that one?
Just that obligation. That's right.
Then who would be responsible for that condition under your understanding?
Haseko. And in fact, under the second area, it's agreed to take on that responsibility. So we've already allocated that between ourselves as a private contractual matter. I'm just trying to get my client's land unencumbered. Again, not to beat a dead horse, but to make the land more financeable.
Don't you agree that it would be helpful if Haseko was here putting that on the record?
I think Mr. Tabata, I saw him here at one point. Yep, he's here.
No, he can offer to speak. I'm just saying the petitioner has represented that some third party, Haseko, is willing to step forth and fully be responsible for condition 19. That's not on the record. An evidentiary hearing, a contested case would clearly put something like that on the record, and that's where staff is coming from.
Well, I mean, to the extent the commission thinks that's a relevant consideration, I don't think so, because I think as a matter of law, what's relevant is that a condition of HRT conveying the 150 acres to the state is that the LUC issues an order relieving the 123 acres from that obligation.
The LUC
but-
was not party to that
No,
stipulation.
no, I understand. All I'm saying is that if that condition fails, then it creates a whole potential downside problem in terms of whether we decide what is our remedy for that failure. And do we take back the 150 acres? Do we sue the state and argue that, we're entitled to get that land back? Or money damages, which is, 10, 15, $20 million? Who knows? I mean, it just seems like what we're requesting is not an unreasonable ask under the circumstances.
Thank you. Mr. Oʻahu, Commissioner Oʻahu, are you satisfied with the response? Or you want to follow up?
I'm satisfied with the response. Absolutely. Thank you.
Thank you. Commissioner Carr-Smith.
Thank you. While we're waiting for Mr. Tabata, is this agreement that you have with Haseko, is that something that happened since you were before us last time, since then and now?
No, that agreement, I don't have the exact date. I'll have to, no, it far predates
Okay.
these proceedings.
So if there's an agreement somewhere that says that you're not obligated for condition 19, where can we find that?
I can submit it after the hearing, so for if the commission decides to take this under advisement, I can submit it.
So I'm going to take a 5-minute break. And let me suggest that during that break, it would be really helpful if you and the representatives from Haseko might be able to put something on the record here today regarding condition 19 and who would be responsible.
Okay, I'll try to reach Mr. Tabata.
Sure. This is Ariana. We have Curtis Tabata on the Zoom, and we'll bring him up after the recess.
Yeah, so I'm going to take a recess now till 10:15. Hello, that you're back with us.
Yes, Chair.
And everybody else is here in person, so we will proceed. So when we took the recess, Ms. Kwan, you indicated that we had public testimony from the Zoom from Mr. Tabata. Is that correct?
Curtis Tabata has been promoted to panelist to speak.
So Mr. Tabata, please state your name and who you're representing, and then proceed with your testimony.
Thank you. Curtis Tabata, attorney for Haseko. I wasn't planning on testifying. I didn't have anything to add to our written statement. But if there's any questions, I'll be willing to answer. I'll try to answer.
So, Mr. Tabata, this is the chair. Reference was made at the end, just before we recess, that there is an off-site agreement that's not in evidence before this commission between Haseko and the petitioner, by which Haseko has agreed to be responsible for the off-site infrastructure associated with the 150-acre agricultural parcel, thereby relieving the petitioner of the responsibility. Did I state that correctly, Mr. Lee?
Yes.
So, Mr. Tabata, can you speak to that?
Yes. Haseko's responsibility for the offsite agricultural infrastructure, that's pursuant to the Fifth Amended Memorandum of Understanding that Haseko executed with the Department of Agriculture. And that was that MOU was the basis for our motion to extend the time period to perform those offsite infrastructure. We filed that in early 2024, and the commission issued its order, I believe, in October of 2024, granting our motion and recognizing our obligation. What the order also did was it amended condition A1, which requires Haseko to perform that offsite infrastructure. So it may not be in the record in this DR, but it's the commission's own order. And I don't see why. I think you can, take that into consideration, and rely on it. It's the commission's own order.
So, Mr. Tabata, would Haseko be responsible for 100% of the off-site infrastructure expected by the Department of Agriculture for that parcel?
I believe that's what it says in the Fifth Amended MOU. We're responsible. We're the only ones who signed it, along with the Department of Agriculture, and it sets forth the irrigation infrastructure, the temporary infrastructure, and the permanent infrastructure. So we're the only, landowner who signed off on that. So I think you could make that conclusion. I think what the RK2 Partners is concerned about is if for some reason Haseko were to cease to exist, for example, then the other landowners are potentially responsible in that case. So, I think that's the risk that they're trying to avoid.
Thank you. Commissioners, any questions for Mr. Tabata? Petitioner, any questions for Mr. Tabata?
No, the only other fact that if you know, Curtis, is one of the principals of my client inform us that Haseko's actually bonded some of those improvements. Are you aware of that?
No, I'm not aware of that. I have no information to dispute that, though, so.
Okay, all right.
So for the record, that was Mr. Lee and Mr. Tabata talking to each other without naming themselves. Yeah.
I'm sorry, Curtis Tabata. Chair, if I could add one more thing to the discussion.
Please.
There's been discussion about the different landowners, and how that may affect responsibility to fulfill conditions or to be subject to an order to show cause. Currently the petition area has not been bifurcated. It is whole. So if there, so before cause were to be brought because one of the landowners committed a violation of some kind, the risk of reversion would apply to everyone. Okay, all landowners, because the petition area is not bifurcated. Okay. If that were to happen, I'm sure the other landowners who were not responsible would file a motion to amend the DNO to seek bifurcation so that they don't get penalized. Okay, but that's what would need to take place in order for you to say downzone one parcel, one landowner, and not another. Okay, it's a single petition area, it is. I believe it would require a motion to amend the DNO in order to bifurcate the petition area into different landowners. And a motion to amend the DNO can only be filed by a party. Okay, that's my reading of the rules. So the Land Use Commission itself, I don't believe it has the authority to bifurcate the petition area unilaterally. That's my reading of the rules, at least. So I just wanted to add that to the discussion.
Yeah, thank you. That's helpful. Commissioners. Mr. Yamane.
Mr. Chair, I had a question for the petitioner, if that's okay.
Yes.
Thank you, Mr. Lee. Appreciate you going over and kind of reminding us what we're here for, because that was really helpful. So I just wanted to, like in my mind, kind of start out. So your deck ruling was for two things. One for determine if there's substantial commencement of work done, and the second was separately that you guys, this 150, I'm looking at the 123 acre is not encumbered by the requirements to provide offsite infrastructure. Is that correct?
Offsite infrastructure for the ag park.
Right.
That's correct. Yes.
So, and way back when the land use did this boundary amendment to convert from ag to urban as a property in whole, correct?
Correct.
And since then, many years have passed, and now it's all split up in different properties. Oʻahu did the solar farm, and that's 30% of entire property. So you're worried that a show cause or the obligation for this offshore infrastructure will cause your lenders to have this risk, like not lend money basically to develop. That's
Correct.
your concern. What, like, if nothing happened, like what prompted you to worry about it? What brought it up to you to say, hey, we need to, was it like lawyers telling lawyers this could happen, so we should do it? Or like, because that just brings attention to it. Whereas if everything just went through and the land use issued its order and you did what you needed to do, what I'm curious, what triggered it?
So what triggered this is Del Wong, who was Reuben Wong's associate, colleague, whatever, called me one day and told me, hey, Terry, did you know that there was an agreement with OPSD and HRT where HRT acquired the 150 acres for the ag park and conveyed it in exchange for being released from the obligation to do the offsite infrastructure improvements? And I said, no, I didn't know that, because, as I testified earlier, it's like drinking from a fire hose. There's so much documents in this proceeding. And so when he made me aware of that, I filed an earlier petition, and it occurred to me that, look, one of the issues is that our land, our 123 acres, should be protected from being reclassified. And correctly, the staff pointed out that, hey, the commission doesn't have that authority. You can't say something stays a certain land use classification in perpetuity. I got it. So that's why I followed the subsequent petition, because, well, if at a minimum, I would like a ruling that if there's going to be a reclassification, then you got to follow the full bore requirements of the statute for reclassifying land. not just using an order to show cause and say, hey, you didn't, somebody didn't perform a condition, therefore we're going to revert it back to ag. Okay. So that was the genesis for that. And then, of course, I want the benefit of the bargain the HRT negotiated 20 years ago and relieve our 123 acres from the obligation to provide that offsite infrastructure for the ag park.
So backing up to your first thing about Dell on, I know Dell, by the way, how is he doing?
Good.
He's good. What, like, you mentioned that there was agreement, but that agreement wasn't with the Land Use Commission, it was between who again? OPSD and?
OPSD and HRT, which is our predecessor that owned the 123
But
acres.
how would they be able to take off the requirement of something that was issued by the land use? Why would that worry Dell that when it's a land use that issued that condition, that this
So,
agreement is, now I gotta worry about this agreement?
so the, and you know, I'm just surmising that this is the case because clearly Reuben Wong, you know, knows what the rules and procedures and so on are for the Land Use Commission. The understanding was that OPSD would support the effort by HRT to have its 123 acres relieved of that obligation. And if, and you know, the stipulation, which you have a copy of, actually states that that is a condition for the transfer of the land, that the LUC shall issue such an order. Okay. And so all I'm arguing before the commission is that the commission should issue such an order. I'm not saying it's obligated. It's clearly not obligated. I'm just saying it should recognize and issue that order because that was the bargain that was worked out between OPSD and HRT. And I would also point out that, look, OPSD's function is to determine what is the best use of state land and to advise the commission accordingly. OPSD 20 years ago decided, yeah, that's a good deal for the state. Get HRT to buy the 150 acres and convey it to the state in exchange for releasing HRT's land from that obligation for offsite infrastructure improvements to the ag park. Perfectly reasonable. Went before the commission on an order to show cause because the commission then, you know, issued an order to show cause as to why they shouldn't revert the land back to ag because it didn't see enough progress being made on the development. And we, you know, I mean, I'm old enough to remember the trials and tribulations that Herb Parita had with his development projects, you know, not just this one, but Ko'olina as well. You know, I mean, he just overextended himself. And so the commissioners back then were frustrated because they didn't see progress. So they found an order to show cause.
Okay.
And that's when this whole issue came up about, you know, and so for purposes of that order to show cause, I agree. The commission just held that, look, for purposes of this order to show cause, we're going to recognize that benefit and our HRT's land, its 123 acres, aren't subject to any reclassification risk, but only for that order to show cause. Now, what I'm doing is trying to get the commission to go, hey, you know what? That was the deal. We will recognize that deal.
Right, and then the timing wise, that initial indication for show cause versus the obligation in that agreement that kind of obligated to say, we'll give you this, but the land use gotta give you this amendment in perpetuity, that agreement. Where was that? Did the show cause come first and then the agreement between the two
No,
parties?
the stipulation was in existence and then the order to show call
Oh,
followed.
okay, okay.
Just a
Oh, the other way around?
Yeah,
Oh, sorry.
so what was, it's the, what came first, that indication to show cause and then the agreement to say the land use shall not revert this, that's.
Ms. Gato, do you want to come on record? Or just from the peanut gallery?
December 29, 2003.
Just if you need clarification,
Just
I
for
believe
Ms. Gato,
OPSD.
state your name.
Oh, Allison Cato, Deputy Attorney General for the Office of Planning and Sustainable Development. Sorry, I only partially heard. It seems there's some confusion about the order of things.
Sequence.
A sequence, yeah.
Yeah, I believe OPSD filed a motion for order to show cause. And then there was an order to show cause, and then the stipulation happened. In order to excuse them from the HRT at the time, from the order to show cause, they agreed to
Yes, yep.
Do you agree, Mr. Lee?
stipulation.
So to clarify.
Yeah.
Thank you.
Based on your staff report, on February 26, 2023, the LUC issued an order to show cause and set hearing dates for April 24 to 25, 2003. And then on December 29, 2003, HRT entered into the stipulation with OSPD.
Okay, so they had indication that the existing commission was going to do show cause on the entire property because at that time, Oʻahu Solar wasn't developed yet, right? There was pretty much nothing there.
right.
So because of that, they kind of put in a scare to say, hey, we'll give you this, but because the land use commission at the time already said they might do a show cause, you got to ensure that they don't revert that portion of property back to
Correct.
ag. Okay,
Correct.
thank you, Mr. Chair.
Just to follow up to Commissioner Imani, since the December 29th, 2003 stipulation, have your client or its predecessor owner ever made a motion to amend the original order that required condition 19?
Not to my knowledge, no.
So can you speculate on what the expectation is of how the PUC, how this LUC was going to in effect follow through? And
I couldn't, and I asked Dell if Ruben was available to chat, and unfortunately, because of his age and his health, he was not.
okay, commissioners, anything further for the public witness or the petitioner? Thank you, Mr. Tabata. Appreciate it. So petitioner, going to give you one final opportunity before we go into deliberation to say what you want to say.
No, I just want to thank the commissioners for their patience. Oh,
Pardon me? Oh, if you don't mind. So this would be part of the public testimony. Could you please come forward and are you an attorney? So please state your name and affiliation and who you're representing and then proceed.
Hi, good morning. Deputy Attorney General Kelsey Nagata on behalf of the Department of Agriculture. Just wanted to make a quick comment based on, off of everything that has been said today that, we recognize RP2's argument is that substantial commencement has occurred due to Ho'ohana's representation of the entire parcel. This argument also hinges on the consideration that the entire parcel is the 500 acres, which is what Mr. Tabata had mentioned earlier. That same DNO applies to that 500 acres. Nevertheless, the HDOA's main concern is similar, is if HASECO is unable to perform, who will supply the infrastructure for the ag park, benefiting the Department of Agriculture. And just as an aside, a comment to what I think Mr. Lee and Mr. Tabata were asking about the bonding requirements. There is an agreement in the Fifth Amended MOU between HASECO and the Department of Agriculture to bond a portion of the project to ensure completion of the infrastructure. However, the Department of Agriculture has not been in receipt of any of that bond that was agreed to yet. We are still awaiting, and we anticipate and are working with HASECO to get that in place. Thank you. I'm available for any additional questions.
Thank you. Commissioners, any questions? Thank you very much. Well, wait, what was that? Mr. Carr-Smith.
Thank you. So is it your understanding that HASECO bears the responsibility of providing the infrastructure to the ag park?
I will represent that there is an agreement with
HASECO and the Department of Agriculture, that HASECO will provide the infrastructure. I am not going to commit to say that it is solely HASECO's responsibility under condition 19 of the DNO.
Okay. Well, I think that somebody needs to provide us something in writing that shows that this is a real agreement. And if I saw that, I'd be happy.
Yeah, I think that's kind of what staff is recommending in terms of an evidentiary hearing. Bring the paperwork forward so we can see it in some form.
Or we take a lunch break and you go get the document.
It's another way. So, wait,
Oh, you have it? Oh,
what do you have?
I have a copy of the Fifth Amendment to the amended and restatement of memorandum of understanding between HASECO and the Department of Ag, which provides for that obligation.
And you're wanting to put that evidence on the record in the matter of the declaratory ruling at this time?
I think if it'll help move things along, yes.
was there something previously in writing that made your client responsible? And then this was subsequent? I mean, is there anything that shows release
I
of?
don't know how we on the fly accept it, review it. That's what a contested case is all about. That's why the staff was coming from that perspective originally. But before I make a decision or ask further questions on that document, Commissioner Lee, you had some question?
Yeah, thank you, Chair. Madam Deputy. What are your thoughts on how long you'll wait to get the bond documents?
I cannot answer that at this time. We have been in my client has been in conversations with HASECO in terms of the status update and what has been occurring. And so we can work, are willing and continue to work with HASECO to ensure that the bonding requirements per the Fifth Amendment MOU is complied with.
Would you wait a year?
I cannot commit to that at this time.
Okay, thank you. And follow-up questions for Mr. Lee. If these proceedings were to go to an evidentiary hearing, a contested case, what would be the ramifications and what would be your objections to that?
You know, it's really just the dragging out of this issue longer because I don't think it's necessary. I don't frankly think it's necessary based on the testimony that you've received, which confirms both by HASECO and Department of Ag that there's an agreement. An agreement exists between them where HASECO is going to perform these obligations. So seeing the agreement is just going to verify what they've testified to, but the testimony in my mind is sufficient.
I'm not sure if this question goes to staff or anyone else, but if, let's say the bond is not executed, what's the next step then?
Thank you, Commissioner Lee. Dan Hardenker, Executive Officer. One of the disconnects that we're having here is that from the commission's standpoint, this condition is out there. We don't care who satisfies it. So these agreements are between the private parties, and I don't, unless this commission deems it proper, the difficulty is why would we want to release one party just because they've agreed to it amongst themselves? And I think that's the disconnect that's going on here.
Okay, so maybe the question should be for Department of Agriculture then. What would you do if the bond fails to be executed?
I think similar to what Mr. Orndegger was saying is that it's between the parties to determine next steps to ensure that the condition is met, and which is why HDOA has concerns regarding if HASECO is unable to perform, then who? and I understand this is kind of a circular argument here, and we're kind of running around in circles. But that being said, procedurally, HDOA would have to consider options, and one of those options may be for an order to show cause. However, we have not reached that point, nor are we implying that that is necessary at this point. And again, the HDOA needs would need additional time to consider those options available to it when that situation arises.
Okay, thank you. So if Haseko were to fail to provide you the bond, then you would have to go to the remaining parties, or if Haseko went bankrupt, you'd have to go to the remaining parties and try to get them to comply with their the obligation. Is that correct?
Under the LUC order, that is what HDOA understands should occur.
So it's your position then that there is an agreement. It's just that you want proof that it will be complied with.
HDOA is not arguing for compliance with or from Haseko at this point. HDOA's main concern, again, is should Haseko fail, which is just has been raised, then under the condition, which landowner, if any, will abide by the DNO condition 19.
So it sounds like this is like an insurance policy for you, because in case you don't know who to go after, you have this leverage on them that somebody has to do it.
HDOA's position is that that's what the condition says, and that's what should apply.
Okay, thank you.
Yeah.
Commissioner Yamane.
Thank you, Mr. Chair, for the petitioner again. So hypothetically speaking, if there was within that agreement between the two parties that required the parties to go and get the land classification in perpetuity originally, if that wasn't there, and the existing commission gave no indication of show cause, would, hypothetically speaking, would you say you would not be here asking for a deck ruling for both of those issues, or you would still be here?
I think I would still be here because, again, my primary motivation for this petition is to remove underwriting risks from a lender that would evaluate whether to finance my client's project. So I think I would still be here, given the stipulation. And you know, I want to
Stipulation.
the 2000 and the December 2000 and
Well, one of my hypotheticals is that condition didn't exist.
oh, the stipulation didn't exist.
Yeah.
Oh, no, I wouldn't be here.
Okay, thank you.
Yeah. no,
Thank you, Mr.
clearly.
Chair.
Yeah.
Thank you. Commissioners, anything further? Okay, now, final comments from you, sir.
Thank you, Chair. Mr. Ordedecker made the comment, why should the LUC interject itself in relieving and granting the order that we're seeking? And the simple answer is because that is what my client's predecessor in interest bargained for in exchange for acquiring the 150 acres and conveying it to the Department of Ag. Pure and simple. Now, that condition in the stipulation is that the LUC shall issue such an order. All right. The LUC is not obligated to do it. I'm here today seeking that. If the LUC denies it, then that condition fails. And as I testified earlier, that enables us to seek recovery of that 150 acres from the Department of Ag. The offsite infrastructure to the ag part's moot if we prevail on that claim. And I feel pretty strongly that we have such a claim. I don't want to pursue that. I want the ag part. I'm a supporter of ag. I live in Waimanalo. All I'm asking is for something that was negotiated and agreed upon and RK2 Partners predecessor in interest, our HRT performed. So just do the right thing. Thank you.
Thank you. Just doing a time check here. So we'll now enter into deliberations. So given that the matter in front of the commission is a declaratory ruling pursuant to HAR 15-15-100, there are a few different ways that the commission may choose to proceed. One, we can deny the petition that the question is speculative, lacks standing, adversely impacts the state, commission, or officers or employees in any litigation which is pending or expected to arise or lacks jurisdiction. Two, we can issue a decision on the matter contained in the declaratory order. Or third, we could set the petition for hearing before the commission. So the commission will now consider the request for declaratory ruling as presented by the petitioners. And I asked for the commission for discussion at this time, and the chair will entertain any motion by the commissioners. So what is your pleasure, commissioners? Mr. Mayasato.
Thank you, Chair. Yeah, I just have a comment for discussion. I'm not saying if I agree or disagree with any of the positions from anyone at this, within my comments. I guess my biggest thing is we set precedents. This is gonna set a precedence for future hearings. And like one of the commissioners alluded to, we need pretty much a roadmap to follow this 30 years of deals, conditions, and everything that was done prior. Being that it sets precedents, one of our obligations is to have a full and, complete record upon which we can make and base our decisions. And I kind of feel like today we kind of went all over the place and not a clear enough picture. Some assumptions, some verbals. And so I would just caution, and I'm more in favor of moving forward with our contested case hearing.
Thank you, Commissioner. Appreciate your comments. Other commissioners, I'll give you an opportunity to comment in advance of any, or make a specific motion if you wish. Commissioner, go ahead.
Sure, I got a question. Can you read up the three options that we have? We have, one of them was to deny.
Second is to decide to grant one or both, deny one or both, or request a hearing for more information consistent with what Commissioner Miyasato was saying.
Thank you.
Who's down there? Is there a light on? Commissioner?
Are we in discussion or
Yeah, I will
we're
invite,
discussing as opposed to
yeah, I will
waiting
invite,
for a motion?
I will invite commentary if you wish, Commissioner, and you do not have to make a motion.
Mr. Chair.
Yes.
Hi, yeah, so just making a statement, it seems to me the best outcome would have been, I mean, hindsight 2020, is that it seems like all this could be resolved without involving the land use commission with all your third-party agreements, two-party agreements. And it would seem to me that it would have been easier to get them to amend the agreement on the requirement that the land use, give this land in perpetuity, instead of saying that's what's in the agreement. So now we got to come to the land use to get that. Because now you're in front of the commission, which is our regulating body that needs to go about its business following existing rules and regulations, which is a lot stricter than having a two-way or three-way agreement that, different entities sit in a room that could have maybe eliminated that agreement, that would have give your lenders a little bit more breathing room to say, hey, we want to make sure that agreement is met, so let's come to the land use to get that. But now you're in our world of the regulatory environment, and now the options is approve the deck ruling because you asked for it because you feel like you need to meet the obligations of this agreement, or deny the deck ruling or go contested case, or kind of put us in a process where we kind of now prolonging this thing even more, because either way, if we're in it, it's going to be lengthy versus if it was settled off to the side with different parties instead of involving the land use. That, in my mind, that would have been the best way. Then you wouldn't be here in front of us. We kind of had the discussion and you could have just resolved it amongst the parties. So I'm kind of like, I'm gonna have to make my decisions based on our regulatory decision making here, which to me, in either way, is not the outcome you're gonna want. So that's all I have to say, Mr. Chair. Thank you.
Thank you, Commissioner Yamane. Commissioner Carsmith, did you? I didn't know if you were requesting an opportunity to speak.
Yeah, I feel a little odd providing my opinions about things at this point, but if that's the way we're doing it.
No, you could withhold and take it on after a motion is made one way or another. Or
Sure,
you could
I'll
make
wait for a motion.
Yeah. Okay, so commissioners, somebody want to make a motion how to proceed?
Well, there's three options again, Mr. Chair.
Well, if Chair, Mel Kelly,
Commissioner Kahela.
after all these years, all the parties being affected, we got some problems going on with OPSD claiming that, hey, you know what? You never meet the substantial commencement use, all these excuses that's being used now by both parties. I think it's about time that we stop kicking the can down the road and finally make one decision. My position is not we deny the request that's currently the petition is filing. I think we should actually accept and approve the request that the petition is filing. And if the other commissioners disagree, I think that would be my motion. It's been long overdue. I live right up the street. Many of you don't live next to that district that these people are currently looking at putting up this solar farms, and Hoseco looking at putting up homes, and R2K putting up their businesses over there. So, my opinion, I want this project completed, and I'm not sure how long it's going to take if we go through all these other motions and prolong this project another 5 years, 10 years. Let's get it done. So my motion is that we grant the petitioner's request.
So
Thank
just allow me to try to restate that. Commissioner Kahele, so if I understand what your intent is, and I'm going to say it, and then you can affirm or change it. You would like to move that the petitioner's request for this commission to affirm that it has directly or indirectly achieved substantial commencement of the project. And secondly, that it's relieved from condition 19 specific to its portion of the parcel.
That's my motion.
Do I have a second to that motion?
I'll second that.
Commissioner Wu seconds that motion. So I think you just spoke to your motion, but do you want to add anything to it, Commissioner Kaheda?
No, you know what? I think this project needs to be completed. Like I said, I live right up the street. I look at that solar farm every day. I look at the project sitting there. It's about time that we make a decision and get this project completed so everybody can move on and kind of end the nightmare for all of the parties that's involved. Thank you.
Thank you. Commissioner Wu, you want to speak to your second?
Yeah, and maybe I'm naive, but I believe there is an agreement made by two parties prior, and I understand Department of Ag in hopes of having someone, I guess, come through with the conditions that was made or the offsite infrastructure or the infrastructure in itself, but the agreement wasn't made by the petitioner. And that's how I view it. And I see substantial evidence that things happen within the acreage of the land. So again, I don't want to kick the can any further down the road, and I do believe there is an agreement made by two parties and not you guys. And I think that agreement should be held by the people who had agreed upon it and not the people who didn't. And again, this process is new to me, and it's lengthy, but I don't think we need to make it any longer than it needs to be. So that's my manao.
Thank you, Commissioner. Let me say at this point that I'm a little concerned that we are lumping the two requests as one in your motion, Commissioner Kaele. Would you be willing to amend your motion so that we take them one at a time? Basically, the question of commencement, substantial commencement on its own, and the question of whether or not they're relieved of condition 19 on its own.
So you want me to make two motions?
Yeah, can we divide it into
Yes,
two motions?
Sure. I'm sorry. Yes, sure. We can make
Would
two
you want-
motions, yes.
So, Mr. Oʻahu, Commissioner Oʻahu, would you be willing to take them one at a time?
Yes.
Okay. Commissioners, further, so as it stands now, we're going to deal with the first motion. Motion, I'll call it 1A, which is which is to approve the petitioner's request for declaratory ruling that substantial commencement, the commencement has substantially commenced on for all intents and purposes, the property they own. So I'm asking the commissioners if they want to make comment on that particular motion.
Mr. Chair, I had a clarifying question for either petitioner or staff. On the deck ruling on the 1A, is that referring to the entire parcel that was originally amended for ag to urban? And then on 1B, is that specifically only for RK2? Just wanted to clarify that with, I guess, anybody in this room.
Well, before they answer, let me say that is the reason I asked for it to be separated.
And get someone to clarify that.
Mr. Chair, Daniel Orodankar, Executive Officer. I mean, to a certain extent, I would rely on the Deputy Attorney General to comment on this, but from the standpoint of the request that's being made by RK2 Partners, and I do not believe that we can make a decision with regard to parties that are not, regard to landowners who are not a party to the petition.
So what do
In
you,
other words, this would apply just to RK2 Partners.
both motions?
Yes.
So
Chair?
Attorney General? I just want to get a clarification.
Yeah, I was going to ask if we could go into executive session, please, pursuant to 92-5A4.
Do I have a second to the motion to go into executive session?
I'll second Commissioner Lee.
Sorry, this
All
is Deputy Attorney General Goldman. Can you please specify the purpose of the executive session? So pursuant to 92-5A4 in order to consult with your Deputy Attorney General, blah, blah, blah. Please.
Yes, I mentioned the HRS. And yes, it's in order to consult with the Attorney General regarding Commission's powers, duties, privileges, immunities, and liabilities.
Are you good, Attorney General, with
Yes.
that?
Yeah.
Okay. So since this is the first vote of the day, it'll be a roll call vote on the motion to go in exec session.
The motion is to go into executive session. Commissioner Carr Smith,
Aye.
Commissioner Lee,
Aye.
Commissioner Kamakeo, hello,
Aye.
Commissioner Uu,
Aye.
Commissioner Yamane,
Aye.
Commissioner Miyamoto,
Aye.
Commissioner Kahele,
Aye.
Commissioner Hayashida is absent, Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Okay, let me invite the Attorney, Deputy Attorney General, and also our Executive Director to join us in exec session. And for everybody, appreciate your patience. Hopefully this will not take too long. So we'll be recessing the primary session and go into exec session. It's now 11:03. Second session at 12:36. Just let me note for the record that my clock had been off. So when I said it was 10 o'clock earlier, it was 11. And when I said it was 11, it was 12. And I apologize because there's probably some hungry people in this room. I didn't realize. Also, let me note for the record that we're going to lose one commissioner at 1 p.m. today, which is 24 minutes from now. But we'll still be able to conduct business because we have a quorum. With that, we did have an exec session. I would like to give you just a brief summary. We talked about really what our roles and responsibilities were in generic declaratory rulings and what we might be able to do and not do and to establish precedent on a matter such as this. We did not deliberate on the merits of the petition or any of the arguments for or against it or the motions that are before us. So it was just simply to interact with our Attorney General and get clarification on what we can and cannot do and how we do it. With that, I'd like to ask for the commissioners and preferences, since we are running so late, if they'd like to take a lunch break at this time. No, thank you from Bruce. Yeah, we're going to plow through.
Let's plow through,
We're
Mr.
going to
Chair.
plow through. Is that okay with the petitioner? All right. So we're back in deliberations. Commissioner Kahele, it was your motion that was before the table and we had bifurcated it into a 1A and a 1B. Did you want to ask? I understand you may want to make the following.
Yeah, I made a motion to accept the petitioner's request. And that's currently right now on the table.
That's what you did, yeah?
Yes.
You want to stand with that?
Yes.
Okay. So, commissioners, the motion is on 1A, which is on the portion of the declaratory recooling that has been in the petition, whether or not a substantial commencement has occurred. And that's only the part that we're talking about now. So commissioners, any further comment on the motion?
Chair.
Commissioner Lee?
Can I clarify whether motion 1A also includes the request that any reclassification by the LUC must be done in accordance with section 205-4? Is that part of, because that was part of the first request. And so is that also part of the motion that is?
Executive Director.
Yes, it is, but, and it would be even if
By
it
default?
wasn't stated, but yeah, by default.
Okay, thank you.
Thank you. Commissioner
Chair.
Carr Smith?
I have a couple of comments. I know that we're bound by this agenda. And this agenda states that we are dealing with TMK 19421. So with that, it makes it more challenging to accept, in my mind, what I think. I agree that the petition area is what we're talking about, but that's not what the agenda says. And my other comment is that if you came here to seek relief from the second item, I really wish you would have brought more evidence of those agreements, whether it's the agreement between you and OPSD or OPSD or Department of Ag and HSECO, or you and HSECO, or the many options. I think it would have been much cleaner if you would have provided proof of those for us. Those are my comments.
Thank you. Anybody else? Usually your light's on. Does that mean you want to talk? Anybody else? So, I'm going to speak to the motion and its two parts, in commentary, but I'll be willing to vote on them individually. My sense is that when I look at the petition area as a whole, that there has been clear evidence of substantial commencement, and that it would be afforded to all the landowners there. So I am inclined to vote in support of 1A. I will reserve my vote on 1B because I don't feel similarly on that one. But we'll discuss that when that comes up. Anybody else? Let's have a roll call vote on the motion. So please restate the motion for clarification.
Thank you, Mr. Chair. Motion 1A is to approve the declaratory ruling request for affirmation that there has been substantial commencement on the parcel. Commissioner Kahele,
Aye.
Commissioner Oʻahu,
Aye.
Commissioner Kamakeo, hello.
Aye.
Commissioner Carr-Smith,
Aye.
Commissioner Yamane,
Aye.
Commissioner Miyamoto, Miyasato,
Aye.
Commissioner Lee,
Aye.
Commissioner Hayashida is absent. Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
So now let's talk to the second motion, which is whether this petitioner, whether the owner of this parcel, which is only a portion of the total petition area, should be relieved of condition 19 based on the evidence that's before us in the record now. And do you want to speak to that, Commissioner Kahele, your motion?
You know, I basically explained why and I believe the petitioners submitted all the information that they could to justify the request. And for this property, it's only pertaining to RK2 property. It's not pertaining to the other properties that's involved. So, yeah, so that's basically it. Okay, you know, I forget these commissioners and the commissioners has heard enough of what's been going on out there at this location, and it's about time to get these projects going.
Okay. Commissioner Wu, do you want to speak to your second?
I'll second just for the thought. I'm sorry. I'll just stand on my second.
Very good. Commissioners, any further comment?
Thank you, Chair.
Commissioner Miyamoto.
Yeah, again, as stated previous, I would have appreciated if some of those documents would have been provided. But I guess due to the fact that we had confirmation from the department that Joseco is taking the obligation, I somewhat gotta agree with Commissioner Kahele that sometimes things just, it's a kind of a private matter. that you folks need to work out. The obligation is still there no matter what. So I'm hoping everything will be honored. Sometimes that's the best we can do, yeah, and move forward and get things done for people, for the residents. So, yeah.
Thank you. Anybody else?
Mr. Chair.
Commissioner Yamane.
Thank you, Mr. Chair. I respect my fellow commissioners, especially Baramel down there at the end. But for this one, I'm kind of having a hard time issuing a vote yes. I just feel like this decision should be settled outside of land use, but obviously it's presented us in a form of a deck ruling. So now we got to make a decision specifically on whether RK2 should not be, obligated to the offsite infrastructure. And in that case, I can't see myself voting yes for this, Mr. Chair. So I'll be voting no on this. I think this shouldn't have been brought to the land use and should be taken care outside the land use. So I'll be voting no. Thank you.
Thank you, Commissioner. Anybody else? So the chair feels similarly. I think that it is a private matter and it should be settled privately among the landowners of how they're going to fulfill the requirements of condition 19. And I think there's a plan in place. And I think it's a good plan. And I think we've heard today that all intents and purposes, the parties that are the owners, that represent the owners, intend to follow through with that. I don't think it's appropriate for the Land Use Commission to set precedent and get in the middle of that by relieving one of the parties at this stage of the game. I think the more appropriate vehicle, if you really wanted to pursue it, as my message to the petitioner, would be a motion to amend the order in the first place. And I think that could be accommodated in a relatively straightforward amount of time. It wouldn't be kicking the can another 23 years. It'd be kicking the can about 180 days. So I'm going to vote no on this second part. Anybody else? Okay, let's take a roll call vote.
Thank you, Mr. Chair. The motion is to release the petitioner of its obligations under condition 19. Commissioner Kahele,
Aye.
Commissioner Oʻahu,
Aye.
Commissioner Kamakeo Hello,
Ole.
Commissioner Carr-Smith,
No.
Commissioner Yamane,
No.
Commissioner Miyasato,
Aye.
Commissioner Lee,
Aye.
Commissioner Hayashida is absent, Chair Giovanni.
No.
Mr. Chair, we have 4 votes for and 4 votes against. We do not have a decision.
So we have no decision on the 1B. So what are our options?
Someone can make another motion.
So the motion doesn't pass.
Motion does not pass.
Chair,
Commissioner Carr-Smith.
I would be willing to change my vote to yes.
Expect that and allow that to happen. So let's just to make it clean. I'm going to do it a little differently. So I think I don't want to get tied up in too many motions here, but Attorney General, could I call for a second roll call vote for the motion based on the comments that I just received from Commissioner Carr-Smith?
Yes, Chair.
Okay, so let's have a second roll call. Let me ask you to do the roll call vote again.
Okay. The motion is to release the petitioner of its obligations under condition 19 of the decision in order. Commissioner Kahele,
Aye.
Commissioner Lee,
Aye.
Commissioner Miyasato,
Aye.
Commissioner Oʻahu,
Aye.
Commissioner Carr Smith,
Aye.
Commissioner Kamakeo Hello,
Ole.
Commissioner Yamane,
No.
Chair Giovanni.
No,
Thank you, Mr. Chair. The motion passes with a vote of 5 in support, 3 noes.
Chair,
okay, thank you.
Chair, Deputy Attorney General Goldman.
Oh.
I just want to make one more comment before you move on from this particular agenda item. Something I forgot to flag earlier, which is that the 4th recommendation in the staff submittal, if somebody would like to make a motion regarding that recommendation, it might be helpful. The recommendation was whether to authorize the chairperson to execute the declaratory order necessary to effectuate the decision, subject to review and approval by the Department of the Attorney General.
Basically, that's the formality of getting a written order out. But I could do it as chair as opposed to involving the whole commission. So do I need a motion on that, Melissa?
Chair Mel Haley, I make a motion.
Wait a minute. I didn't see what we need. So do I need a
I
motion?
apologize. If someone wants to make a motion, they can. You also don't have to vote on it, and then it would not be something that would attach to the votes you just took.
My preference is let's do it formally. Mel, make your motion.
Chair, I make a motion.
That motion that I could execute the order.
Absolutely.
Yeah. Do I have a second?
Second.
Miyasato, second. All in favor indicate by saying aye.
Aye.
Any opposed?
Aye.
So be it. Thank you, Melissa. So that concludes this agenda item. Thank you very much for your time and patience.
Thank you, Commissioner. Appreciate your time. Thank you.
So commissioners, I'm gonna give you a second chance to take lunch. Want lunch now? Or you want to just plow through the rest of this? It's not.
It's just gonna take us a couple, it should only take us a few.
I think we could do the rest of the agenda in 20 minutes or less. So can we do it? Yeah, okay, no lunch. Koike, thank you for joining us.
Mahalo, Chair.
Yeah.
I'll hang on till 1.
Yeah, we might be finished by then even, so hang on.
Yep.
That's what we always do.
Okay, next agenda item is the tentative meeting schedule. Mr. Orendenker.
Thank you, Mr. Chair. Tomorrow, we will again be here for various updates as.
Chair, I think we're supposed to do the
Minutes
approval
from
of
November 7, right?
Okay.
Was that it? Yeah. Sorry, Mr. Orendenker, I'm gonna
Fine.
go backwards before I go forwards. I skipped over that inadvertently. Ms. Kwan, we're going to consider our third order of business is the adoption of November 7, 2024 minutes. Ms. Kwan, has there been any written testimony on the minutes?
No, Mr. Chair.
Has any members of the public signed up to testify on the minutes?
Seeing none, Mr. Chair.
Commissioners, are there any corrections or comments on the minutes? If not, is there a motion to adopt the minutes from our meeting of November 7, 2024?
So moved.
Moved by Commissioner Imani.
Second.
Second by Commissioner Kahele. All in favor indicate by saying aye.
Aye.
Aye. Any opposed? No. Minutes are adopted from November 7, 2024. The next agenda item is the tentative meeting schedule. Mr. Orendenker.
Thank you, Mr. Chair. Tomorrow, we will be once again here at the State Office Tower for various updates and a discussion with the Attorney General pursuant to the posted agenda. On the 22nd and 23rd, we currently do not have anything scheduled, but we would ask the commissioners to hold those dates open. February 5th, we will be here again for HASECO updates and updates from Arnold Wong and legislative updates. On November 6th, we currently have an open date. On not November, February. On February 19th, we will be on Maui at the MAC for the Emmanuel Lutheran Status Report. The 20th is currently open. March 5th and 6th and 19th and 20th are currently vacant, as is April 9th, 10th, and 23rd and 24th.
Commissioners, any questions?
Chair,
Yes,
I have,
Commissioner Miyamoto.
I'd like to address, January 22nd. Being that this is the new year, Chair, I'd like to ask if we could agendize an, election of officers to start off the new year on the 22nd, and if that could be a, hybrid.
So is that an ask or a motion or what?
It's a
ask.
request. It's a request. Are you referring to January 20th, Commissioner?
Second, yeah.
20th. 22nd is Saturday. Oh, no, I'm looking at February. I'm sorry. February, January.
I'll have
Okay,
24.
yeah, 22nd, yeah. Okay,
So what's my options?
you can ask me to agendize it or not.
Yes, I mean, the protocol for years has been to do the election at the end of the fiscal year for the
But
next.
that,
fiscal
that
year.
wasn't done last year.
It was.
That was done in April.
So
Because,
April.
I wanted it to be in the fiscal year.
Sorry, this is Ms. Kwan. Last year, we did hold the election in April, but it was to be effective July 1st, election of officers. They didn't take office April or May.
But there's nothing.
Either way, I've got no problem agendizing this
Okay.
item for January 22nd. So let me ask staff to put on the agenda, and let me ask Commissioner Miyasato to work with staff to get the wording clearly exactly what you want. And then he'll draft it, he'll submit it to the AG, and then it'll come to me to final approval to put on the agenda. But I have no problem with it.
Okay, thank you.
Okay? Anything else?
Is that an in-person meeting or a virtual meeting? Okay.
Hybrid.
I don't know yet. I
Okay.
will get back to staff and commission if we're gonna do it in person or
Yeah.
hybrid.
Thank you.
Okay? Anything else? Any other questions? Okay, then we will recess today until tomorrow at 9 a.m. here in the same place. Do I have a motion to recess? Second, all in
Second.
favor? We are recessed.